Good afternoon to all. I welcome you on behalf of Jagmohan College of Law, and today we will discuss about origin of writ, and today we will discuss about the law related to the writs under Constitution of India. First, we will discuss about the origin of writ. As I think all the students have joined this live stream. Ayush Tyagi has joined. Good afternoon, Ayush. How are you? I'm waiting. Kindly join as soon as possible so I can start my live stream, because today's topic is very, very, very much important for us. If we are the students of LLB, BLLB, LLM, then it is very important for us. So, a number of students has joined. I think 10 of the students has joined. So, I should start. I will talk about the origin of writ in common law. So, the origin of writ in common law. Writ is a formal written order issued by a body with administrative or judicial jurisdiction. If we will talk about the modern times, then in the modern times, this body is generally a type of court. And in olden days, the writ was simply a written order made by the English monarch to specified person to undertake a specified action. Example, if the king is ordering to the military, if the king is ordering to the military chief to arrange the soldiers for battle at a certain place and time, then it is a type of writ. This is the actual meaning of the writ at that time. We are talking about the origin. In early times, if we will talk, UK, Canada, Australia had a practice of writ of election. You know, the writ of election means a written order issued by a governor general for House of Representatives, state governors for state elections on behalf of king, to local officials to hold general elections. If the students, if we will talk about the types of writs, then there are 5 types of writs in the Constitution of India, which are stated in Article 32 for Supreme Court of India and Article 2 to 6 for High Court. They are: number 1, habeas corpus; number 2, quo warranto; mandamus, prohibition, or certiorari. Someone. So, number 1, habeas corpus means a great and effective writ is this, because habeas corpus was firstly originated in 1215, and in 13th clause of Magna Carta, which was being signed by the King John, habeas corpus was derived from Latin term, which means that you have the body and it is used to secure a person who has been detained unlawfully and illegally. The detention is unlawful if it is not according to the law, and if not strictly following the procedure established by law. The invalid law is followed because the law infringes fundamental law. It exceeds the law enacted by legislature. Article, you also specified the articles, that if the articles we will find out, then Article 20 will say protection in respect of conviction for offences. Article 21 will say protection of life and personal liberty. Article 22 will say protection against arrest and detention in certain cases. Court will check the detention with the help of these articles. If the detention violates, then it is unlawful or illegal detention. Anyone can file this petition on behalf of the detainee. One case is there regarding to the habeas corpus in Sheila Barse versus State of Maharashtra case. The writ petition was filed by the Sheila Barse, which was a journalist who was a journalist. She interviewed 15 women prisoners in police lockup in the city of Bombay in May 11, 1982. She finds two women were assaulted there. So she filed the petition. The court ordered and directed one of Miss A.R. Desai, who was the director of College of Social Work, to investigate it. Finally, it was proved, and the officials were punished, and certain safety measures were taken to the safeguard of the women prisoners. Now we will talk. If we will talk about the limitations of habeas corpus, though a writ of right, it is not a writ of course, means it provides only procedural remedy which guarantees against any detention that is forbidden by law, but it does not provide any other remedy, means does not protect any other rights such as fair trial, etc. Number two, if we will talk about the number two writ, which is quo warranto. So quo warranto is a authoritative writ. Authoritative writ, which means quo warranto is originated in the Latin and in the medieval period, which means by what authority it is used to the person who holds the public office and on what authority it is entitled to him. The concerned person is responsible to the court to explain his authority on which he holds the authority. The person who files this writ is need not to be personally suffered. This writ is filed to test the validity of a election of a person in a university syndicate, mayor in municipal corporation, nomination of members to a legislative council by governor, appointment of chief minister, chief justice, advocate, and attorney general, and university teachers, etc. There is a very famous case. In the case of Purushottam Lal versus State of Rajasthan, quo warranto was filed against the CM of Rajasthan, stating that CM was not elected validity to the House. The court rejects the petition, stating that if the CM holds office without authority, then it is breach of constitutional provision. The office of the chief minister is created by constitution, so member of assembly is not a purpose of office. Raising the questions of the election of chief minister in this writ is not a proper form. It must be raised through an election petition. If a person who had no qualification by appointed as CM by the governor under the article 164 of the constitution, which is unconstitutional, the governor cannot be challenged because he had the discretionary power under article 361, and the appointment will be deserted by the concerned high court. One more case is very famous in this regard. In the case Y.S. Raja, Sekhar Reddy versus Nara Chandra Babu Naidu, a quo warranto cannot be issued for dismissing the chief minister of a state. In this case, on the reason of non-performance of his unconstitutional duty. Conditions for issue of quo warranto. The first condition is the office must be a public one and it must be created by the constitution. Number second, it must be a substantive one. Number third, there must be a contravention in constitution in appointing the person for that office. These are the essential ingredients for the said writ. Now we will talk about the mandamus writ, which means command. Mandamus is developed from Latin word, which means we command. It is an order from the Supreme Court or High Court to the lower or subordinate courts, tribunals, public authorities, and to perform the public or statutory duty. Mostly, this writ is to command, and it will be issued to any government, court, corporation, or public, or to that authority which fails to do their work. And what are the limitations for mandamus? Supreme Court cannot issue writ to the president or state governors. Chief Justice of High Courts against any private individuals. Duties on voluntary interest. Mandamus cannot be issued against any state government to appoint a commission for an inquiry in the state delegated legislative to make further rules in statutory provisions, which is being to directing the government to make reservation in under Article 16 clause 4 you will read, and the complete right of a private person will enforce the payment of money a person in a civil liability. It is a very important case and very famous case, that a Tata Cellular versus Union of India case is there, in which the Supreme Court said that the court cannot interfere in the government freedom in invitation of tenders and refusal of tenders in these types of. The court can interfere if the government's decisions was unfair, illegal, and unreasonableness. These are the some important points of these writs. Number 4 writ is certiorari. Certiorari means to be certified. To be certified, certiorari is issued by a superior court to the inferior or to subordinate courts, tribunal, and other public authorities to submit the record of a proceeding for review. Generally, the writ of certiorari was issued by the Supreme or High Court for questioning the order passed by inferior courts or subordinate courts, tribunals, or other quasi-judicial authorities. Conditions for issue of writ of certiorari. Number 1, there must be a court, tribunal, or an authorized person having a legal right to act judicially, and such court, tribunal, or officer must acted or passed an order without jurisdiction or in excess of judicial authority. If the order was against the principle of natural justice, if the order contains an error of judgment, if it is against the constitution or contravention to the fundamental rights, these are the essential ingredients of this writ. And number 5 writ, which is prohibition, which means stay order. In detail, the writ of prohibition is issued by Supreme Court or High Court to an inferior court to forbid or to stop the order passed by them. The writ of certiorari and prohibition are issued mostly on the similar grounds. The main difference between these two writs are certiorari issued to the to quash a decision after completion of proceedings, but prohibition issued before the completion of proceeding. Suggestion and examples. The writs are initiated to maintain the proper functioning of the person in the public authority and also for the proper functioning of the government. It must be followed strictly and to ensure that there is a proper function is maintained without any malfunctions in the respective fields. Judiciary must play a major and strict role in this. So these were the 5 writs, which is. Good afternoon. Some Ayush Tagi, sir, voice break. Rahul Sharma, good afternoon. Sanjeev Dhiriyan, good afternoon. Chanchal Sharma, good afternoon. Good afternoon. How are you all? You can put your question. You can ask your relevant question to this session. Somebody is telling that, sir, speak in Hindi. Okay, मैं हिंदी भी बोल सकता हूँ, कोई बात नहीं है. I can speak. लेकिन आप मुझे बताइए कि आपको किसी प्रकार का कोई प्रश्न इससे रिलेटेड है क्या? यदि आपको इससे रिलेटेड कोई प्रश्न है तो आप मुझसे पूछ सकते हैं. You can ask any question from me at any time. आपके द्वारा दिया गया कोई भी क्वेश्चन का जवाब हम यहां से देंगे. आप बताइए कि कोई भी. मैंने अभी 5 रिट्स के विषय में आपको बताया, जिसमें सबसे पहले हमने जो रिट बताई थी, मैं यदि रिवीजन आपको कराऊं तो आप मुझे बताते चलिए कि मैंने सबसे पहले रिट कौन सी बताई थी, दूसरे नंबर पे कौन सी बताई थी, तीसरे नंबर पे कौन सी बताई थी, चौथे पे कौन सी बताई थी, पांचवे पे कौन सी बताई थी, और उनसे रिलेटेड जो मैंने जजमेंट्स आपके सामने बताए थे वो कौन कौन से जजमेंट्स थे, वो आप मुझे बताइए। क्या आपने ये जो लाइव टेलीकास्ट है इसको ध्यान से देखा, सुना, और यदि सुना है तो आप मुझे बता सकते हैं कि मैंने पहले नंबर पे कौन सी रिट बताई थी और लास्ट के नंबर पे कौन सी बताई थी। चलिए लास्ट में भी यदि आप मुझे बता दें कि लास्ट में कौन सी बताई थी तो भी मैं आपको। अच्छा, डी के गौतम जी कह रहे हैं सर ये मेरा फर्स्ट सेशन है। और ओके, आयुष त्यागी कह रहे हैं हैबियस कॉर्पस, सो नाइस ऑफ यू आयुष, वेरी गुड। और लास्ट की कौन सी बताई थी, सबसे लास्ट में मैंने कौन सी रिट बताई थी उसकी भी बता दीजिए। राहुल शर्मा, सॉरी सर आई बिकम लेट, गुड। आयुष त्यागी इसका मतलब अपनी जो कंसंट्रेशन है उसको बिल्कुल वीडियो में जमाए हुए थे। आयुष त्यागी बता रहे हैं प्रोहिबिशन, और उन्होंने बताया कि पहली हैबियस कॉर्पस और उसके बाद प्रोहिबिशन। चलिए, इसका मतलब आपको ये लेक्चर आपने देखा है। यदि आप किन्हीं लोगों ने इसको मिस कर गए हैं तो उसको जब ये लेक्चर खत्म हो जाएगा तो फिर उसके बाद में आप इसको दोबारा रिप्ले करके भी देख सकते हैं। अभी हम जो मुख्यतः डिस्कस करना चाहते हैं वो इसी पॉइंट पर डिस्कस करना चाहते हैं कि रिट प्रोविजंस 226 और 32 में जो प्रेस्क्राइब्ड हैं उन रिट प्रोविजंस में किन किन प्रकार के सपोर्टिंग जजमेंट्स हैं और रिट प्रोविजंस किस किस प्रकार की हमें शक्तियां प्रदान करती हैं, रेमेडी हैं। क्या मेरी आवाज आ रही है? Am I audible? अच्छा, वो फोन किसी का बीच में आ गया था तो डिस्टर्ब हो गया, सॉरी फॉर दैट। आप पूछ सकते हैं। पूनम सिंघल, आई एम फ्रॉम जगमोहन कॉलेज। पुनीत सिंघल, ग्रेट। Great. Is there any question related to this topic? किसी का कोई क्वेश्चन है? किसी को कोई क्वेश्चन यदि पूछना है तो आप पूछ सकते हैं। You can ask any question related to this topic. I am not audible. मेरी आवाज नहीं आ रही है। आयुष त्यागी, oh, now I am audible. जी, आप पूछ सकते हैं कोई भी। देखिए, आप क्वेश्चन पूछिए यदि मेरी आवाज आ रही है तो। प्लीज आस्क एनी क्वेश्चन रिलेटेड टू दिस टॉपिक, और किसी भी टॉपिक से रिलेटेड आपका यदि कोई क्वेश्चन है तो आप पूछ सकते हैं। प्लीज, यू कैन आस्क। You can ask any question. Okay, if you are not asking any question, then thanks a lot for your kind support in this session, and आपका बहुत बहुत धन्यवाद। आप इसी तरीके से जुड़ते रहेंगे।